Welcome back. This video is an overview of how divorce works in England and Wales. But first of all, if you're new here, please like this video, subscribe and hit that bell icon so you don't miss out on new videos. First of all, and as always, this video should not be taken as a replacement for formal legal advice. It's just an explainer video to go over the basic concepts of divorce law. The person that seeks a divorce is called the petitioner, and the other party is called the respondent in the proceedings. Proceedings can commence either by way of a divorce petition, a dissolution petition, or a judicial separation petition. So in England and Wales, there really is only one ground for divorce, and it's set out in Section 1 of the Matrimonial Causes Act of 1973. And this ground is that there's been an irretrievable breakdown of the marriage. And a court cannot rule that there's been an irretrievable breakdown of a marriage unless one of the following things can be shown. Under Section 1, subsection 2 of the Matrimonial Causes Act, this could include adultery, unreasonable behaviour, desertion, 2 years separation with consent of the other party, or 5 years separation and no consent is required. Once one of these facts has been established, there is a presumption of an irretrievable breakdown, and if it goes undefended, the court is going to accept it. But in a defended case, the respondent challenges the assertion that there's been an irretrievable breakdown. I should also make brief reference to the Divorce, Dissolution and Separation Act of 2020, but this will not be in force until autumn of this year, 2021. This act is going to reform the legal requirements of divorce, and whilst it will retain the sole ground of irretrievable breakdown, it will remove the need to evidence it with each of these scenarios and instead replacing it with a statement that the marriage has irretrievably broken down. It's also going to make it possible for a joint application where the divorce is mutual. I will do a follow-up video specifically on this piece of legislation when it becomes active later in the year. But for now, looking at these scenarios that show that a marriage has irretrievably broken down, first we look at adultery. There are two requirements when setting out adultery. First of all, establishing the fact that the respondent has committed adultery, and secondly, that the petitioner finds it intolerable to continue living with the respondent. The meaning of adultery was set out in Clarkson and Clarkson in 1930, and this is where there was sexual intercourse between a man and a woman who were not married. However, one of them at the time was married to somebody else. Now that there's a statutory definition of adultery, it clarifies that it can only be sexual intercourse between members of the opposite sex. So therefore this cannot be relied upon by same-sex couples, but it will become an example of unreasonable behaviour. As to intolerability, this is a subjective test. In other words, the petitioner must demonstrate to the court and persuade the court of the fact that it has become intolerable to live with the respondent. In reality, however, this is not likely to be challenged and more likely to be something of a formality. Unreasonable behaviour is the most common basis for a divorce because there's no need to wait around to prove adultery and it can be started immediately. This is something both of a subjective and an objective test. In other words, what the petitioner thinks and what a reasonable person would think. And the petitioner must persuade the court that it's become intolerable to live with the respondent given the unreasonable behaviour complained of. And this is generally looked at as a three-stage process. First of all, looking at what the respondent is said to have done. Secondly, looking at the effect that that behaviour has had on the petitioner in the case. And thirdly, looking at whether the petitioner could reasonably be expected to continue living with the respondent or whether it has indeed become intolerable. Looking at the first type of desertion, which is where the respondent has deserted the petitioner for a continuous period of 2 years, a petitioner would need to show the following things. First of all, the fact that there has been a separation and that there was an intention on the part of the respondent to desert the petitioner. Secondly, that there was no agreement or consent to the separation and there was no just cause for the respondent to leave in the first place. And finally, that the 2-year period was continuous and it immediately precedes the filing at court. In reality, however, this type of desertion is rarely relied upon because if parties have separated for a continuous period of 2 years, they are more likely to consent and agree to the separation. Hence, we have a 2 years separation with consent of the parties. Generally speaking, to show the separation, parties will be living in a completely separate household. Although it is possible to show that there's been a separation within the household, but there would have to be some level of evidence to show that even though they are living in the same house, They are living separate lives, separate bedrooms, and so on. In other words, there must be a factual basis to show that there has been a separation for that continuous period, even though they are not living in separate households. This might be the case where one simply cannot afford to move out into another household until the house is sold and the proceeds are split, by way of example. And finally, moving on to 5 years, if the parties have separated for a continuous period of 5 years, then the petitioner does not need the consent of the respondent. The mere fact that there's been a separation for 5 years is sufficient. Although there are two broad scenarios where a respondent can object and defend a 5-year separation divorce. Firstly, an outright denial that there's been a separation for the continuous 5 years that's required. And secondly, that there might be a grave hardship on the respondent in that they will greatly suffer at the result of this divorce. And when looking at a defence of grave hardship and whether or not it applies, like many other cases, the court is going to consider all of the circumstances of the case, including the behaviour of the parties, before making a decision as to whether or not it applies in the instant case. So by way of summary, until the new law kicks in, there is only one main ground for divorce, and that is that the relationship has irretrievably broken down, and that the petitioner cannot be expected to tolerate living with the respondent. And this is shown either by way of adultery, unreasonable behaviour, desertion for the period of 2 years, 2 years separation with consent, which is more common, or 5 years separation without consent necessary from the respondent, provided there is no valid defence brought to court, in which case a court may refuse to grant a 5-year separation in those fairly rare cases. Just briefly addressing the 1-year rule, this is fairly simple. That is that a divorce petition cannot be filed at court until at least 1 year of the marriage has elapsed. And per section 3 of the MCA, this rule cannot be waived in any circumstances. If you find yourself in this 1-year period and you simply cannot wait, there are 2 areas that you can seek formal advice on, but they're a little bit beyond the scope of this video, but maybe for a later video. The first one will be a decree of judicial separation, and the second would be a decree of nullity. Broadly speaking, these allow the court to make financial orders and children orders within that first year. Briefly looking at same-sex marriage and same-sex divorce, this was dealt with in the Marriage Same-Sex Couples Act of 2013, which came into effect in 2014, which set out the provisions for marriage between same-sex couples in England and Wales. And as to divorce of same-sex marriages, the legal requirements are broadly the same, with that exception of adultery that I mentioned earlier. And for same-sex parties that were married outside of England and Wales, the procedures and the rules are exactly the same as though they were married in England and Wales. And similarly, for a civil partnership and dissolution of a civil partnership, again, the rules are broadly the same as I've just outlined. When it comes to jurisdiction for the court to hear divorce proceedings, one of the following things must apply. Under Section 5 of the Domicile and Matrimonial Proceedings Act 1973, one or more of the following things must apply. Either that the spouses are habitually resident in England and Wales. I'll come back to habitually resident in a moment. Secondly, that they were both last habitually resident in England and Wales, and one of them continues to live there. Thirdly, that the respondent is habitually resident in England and Wales. It might be that the applicant is habitually resident in England and Wales and resided there for at least 1 year before the application. It might be that the applicant is domiciled and habitually resident in England and Wales and resided there for at least 6 months immediately before the application. Both spouses might be domiciled in England and Wales, or either spouse is domiciled in England and Wales. So let's look at those terms and break those down. So habitually resident, this is a complex term and it can take different forms depending on the situation and how you're looking at it. For example, it's possible to be habitually resident in one country but resident in another country. For example, where parties have more than one property and they spend a lot of time in each property, it will need to be decided which of them is the habitual residence. In other words, where they are spending the majority of their time for their core everyday activities, daily lives. Even if they are spending lots of time in another location, it will need to be decided which is the primary habitual residence before the court is able to determine jurisdiction to hear the divorce proceedings. Moving on to domicile, again, this is not particularly straightforward, and there are 3 types of domicile. The easiest way to think about domicile, a little bit like habitual residence, is the country that the party considers to be their primary and main home. But there can also be domicile of origin, that's where the person was born, and if the parents were married, where the father was born. There can be domicile of dependence, that's where an unmarried child is dependent on their father's domicile if the parents are married, or their mother's domicile if the parents are not married. And finally, there's domicile of choice, which is a decision people can make from the age of 16. And all of these issues are important when deciding where to issue divorce proceedings, because as I said, the court will need to decide that it has jurisdiction to hear the case before you file the petition. So as I said, that's a brief overview of divorce law in England and Wales, at least until the new law kicks in the autumn. But please do drop your questions and comments below, but please do not take this video or anything else that you read online as formal legal advice. You do need to go and see a lawyer and sit down properly and seek formal advice. In the meantime, thanks for watching. See you next time.